Hi everyone, my name is Dina from the KW Chamber of Commerce, and I'm here with Jennifer Babe, who's a partner in the Toronto office of Miller Thomson, and Miller Thomson is a member of the Chamber here in KW as well. So Jennifer's background or industry expertise are banking and financial services, automotive, agribusiness, and food. And her key areas of focus are automotive, agriculture, leasing, privacy, and information protection. So thank you for taking the time out of your day, Jennifer, to present this webinar, and welcome.
Thank you very much, Dana, and welcome. We have a maximum of an hour together and a whole bunch of information to cover. So in this hour with you, I'm going to spend probably about 45 minutes going through the slide deck, and Dana's going to post the slide deck for you so you'll have copies later. And we'll be talking about what the statute is. We're going to focus on just one of the things it regulates, which are commercial electronic messages, which is email, and its requirements about emails, which ones are exempt, which ones have implied consent, and then we'll spend a couple of minutes scaring you because the penalties for a breach of CASL are just nasty. And then a bit of a checklist to help you with your compliance work. This is actually the name of the statute. On the street, it's being called Canada's anti-spam legislation, or just plain CASL, because this statute is unique. It does not have an official short title. But I'm bumping into people who say, well, this statute won't apply to me because I don't do bulk emails. I'm not a spammer. Well, that's not true. This statute regulates a whole bunch of different activities, including not just the sending of messages that are commercial in nature, but also prohibiting bad conduct like hacking, phishing, fraud, privacy invasion, collecting email addresses without consent. And there's some other things that are also regulated by the statute that we'll talk about, but the focus today will be on the commercial electronic messages. And if you remember nothing else about today, it's the fact that all of the regulated activities require consent. The statute was passed in 2010, and both the CRTC and Industry Canada have passed regulations. The CRTC, the Competition Bureau, and the Privacy Commissioner of Canada have powers under the Act to enforce different parts of it. As you might guess, the Competition Bureau is focused on the fraud and misleading components mostly, and the Privacy Commissioner on the harvesting of personal information against the new statute. The CRTC will operate the Spam Reporting Center, and more about that later too. The CRTC's regulation came out in 2012. This is the one you need to go to find out the form and content requirements of a commercial electronic message. That's a new acronym we're all going to learn, which is a CEM. And it's also published several bulletins which are available on its website, and the website address is at the end of the slide deck, where you can go and download all of this and take a look at the interpretation bulletins. In December, they also posted some frequently asked questions. Please note the guidelines, the frequently asked questions, are not the law. The law is the statute and the two main regulations that have been produced. The guidelines might help you when you're thinking about the statute, but they won't have the force of law. And here's the crunch one that came out on December the 4th. Industry Canada produced its regulation, and it defines several key terms like existing non-business relationship, which is important to not-for-profits, charities, and clubs and associations, and the definitions for family and personal relationship. And it gave us a couple of carve-outs from the statute for certain limited things. Nobody could prepare their CASL compliance regime until this final regulation came out, and on December the 4th was the day, and that was the same day the minister said This was all coming into effect on July 1, 2014. This was not as long as we had hoped. We had heard that we would get a year. We got 6.5 months. So the compliance window is very short, and as of today, we're down to about 89 days before this regime goes into effect. One of the things that's also regulated, the downloading of computer programs to someone else's device, starts January 15. For example, if you download software, such as an app, to someone's smartphone, or if you repair motor vehicles and plug them in for diagnostics, that will also download new software into your motor vehicle. Just think of a device in your life that doesn't have software in it. And so that's a whole different regime, but we've got a year for that one. Well, less of it than a year now. And here's a scary one. On July 1st, 2017, there will be rights for civil litigation to enforce breaches of CASL. Start thinking class action boutiques. We already have class actions for privacy breaches. Now we're going to face class actions for CASL breaches. So as I said, the statute's very broad, and it's not just spam, and it has the potential of impacting virtually everything you do as a business operation that involves an electronic message, whether it's sent business to business, business to consumer, or even between individuals. Our American friends have a statute, but it only regulates business to consumer. Canada has gone the furthest in the sweep of this legislation than any other country at the moment that has anti-spam legislation, and we are the last of the G20 countries to enact a system. This statute is international in reach. It applies to anyone in Canada who uses a computer system located in Canada. It also applies to anyone, say, in the States or Europe who are sending messages into Canada that are received on an electronic device inside Canada. And we have international treaties among our regulators and other regulators in the world to go after bad conduct in the international e-commerce world. So it's starting to focus on electronic message. The threshold issue is that it has to be a commercial electronic message. The statute is looking at the content of the message you send, not necessarily the identity of the sender. And the Act prohibits sending a commercial electronic message unless the receiver consents to its receipt and the message contains some prescribed information that we'll talk about. With very, very few and limited exemptions and exclusions, an electronic message is technology neutral. They don't care if you send it over your BlackBerry, you're tweeting, you're sending an email out to your LinkedIn account. Those are all going to be counted as electronic messages. And it needs to be sent to an electronic address. Well, that's just about anything, any of those things that receive messages these days, your smartphone, your laptop, your tablet, whatever else you use to pick up your email. Commercial is the crux, and it refers to anything that encourages participation in commercial activity. So offering to buy, sell, lend, or lease, offering or promoting or advertising any of these activities. So if you send out newsletters or marketing materials, that's the part that captures your electronic marketing on being commercial. In determining commercial, the test is whether it would be reasonable to conclude that the content of the message encourages participation in a commercial activity. So it's not just the message itself. For example, if this law firm sent out a notice to you saying the Supreme Court of Canada has decided X today in this particular decision, that's probably just information. But we tend to go on to say, and if you have a problem about X, please contact your Miller-Thomson lawyer. Well, that promotes or encourages participation in our commercial activity, which is the sale of legal services. Or if we had a web link at the bottom of our newsletters saying, you know, come to our website to see more information provided by our tax group. Well, that too would be encouraging commercial activity. And in the defining commercial activity, it's any of the things that are in a commercial character, whether or not done in expectation of a profit. There is no carve-out for not-for-profits, charities, volunteer associations, or anyone in the MUSH sector, municipalities, universities, schools, and hospitals. Say, for example, a hospital runs a gift shop or a cafe, and it does so to be able to bring in some income to keep the overhead of the hospital down. Well, messages about the parking activities or promoting meals in the cafe would also be commercial electronic messages. Money is changing hands as part of those activities. So again, the Act looks at the message, not the sender. There is further guidance as in the CRTC and the Industry Canada guidelines now. They expect to send out more bulletins and post more frequently asked questions from time to time. But basically, if you're procuring goods and services, marketing, advertising, all of those things are going to be caught. So in looking at a CEM, there's the consent requirements, there's the mandatory information that must be included with your CEM, and the mandatory unsubscribe mechanism. The consent part. Privacy law in Canada has basically allowed, for the most part, a really fuzzy, simple opt-out when it comes to information that's not overly sensitive. So people will go onto a privacy site and the checkbox for consent will already be checked. And yes, you know, it's already deemed you will consent to receiving marketing information using your home contact details. That does not work under CASL. CASL is the very opposite. CASL requires an express consent, and we'll talk about some implied consents, and proving that you got consent is on you as the sender. So we'll talk about having to have a due diligence defense to be able to record and capture consent in case you have a complaint. The request to seek, when you're seeking consent, must be set out clearly and simply. There is no little tiny mouse print in gray pale type at the bottom of the email string. It's got to be clear and prominent. And it must contain the prescribed information. Say, for example, you use a third party to do your marketing. You would then be needing to put out your information about who you are, how to contact you, and the name of your marketing firm and how to contact them. So you need to have express consent to install another program on someone's computer, thinking about, say, an update of an app, or alter someone's transmission of data. Those consents have to be separate. They cannot be bundled in with the consent for receiving CEMs. From the guidelines produced by Industry Canada, here's an example. If this was on your smart device, and say you were buying a t-shirt online from a shop, there might be a box to accept the terms and conditions of the sale. Then you might be getting an agreement to download their software for their loyalty program or to receive future communications about their t-shirt sales. And you would also be there for your privacy policy. Now, if you look at this consent requirement has empty boxes, and you'll see someone actually has to click on the box to give a positive act to demonstrate consent. They cannot be pre-checked boxes. You may also get consent orally or in writing. If you were, say for your example, you were running a Girl Guide pack, you might now have a consent form for parents to enroll their daughters in the Girl Guide pack that allows the electronic communication with the parents in the Girl Guide pack, with the leaders of the pack, to about, we're meeting Tuesday night, the spaghetti supper is next Saturday, all of those sorts of things. There's a list there of the information that must be included in the request. Opt-out does not work, and since the onus is on you to prove that you got consent, the guidelines say oral consent might be, say you have a service center or a call center, you could record the oral consent. And in this law firm, we are putting in our contact management database a box where if I met you at a conference and collected your business card and said you wanted to receive a Miller-Thomson publication, I would record where I met you and that you actually told me you wanted to receive the Miller-Thomson newsletter. That would be oral consent. Then writing consent. And writing you have to be able to say. So if you have a retail store and your salesperson says, would you like to receive more marketing materials about our sales of product X, you might have a paper form at the counter that the customer would sign or insert his or her email address. You would need to collect those written consents to be able to track them in case of a future complaint. So pre-checking the box is not permitted. Having a click box to actually have the customer make a choice is permitted. Or, as you see on this sample, you could insert your email address. That too would be a positive act of the individual giving his or her email address to you. That's express consent. But consent can also be implied. And this slide is probably the one most of you need to be aware of for your marketing and activities or relationships with your customers or your suppliers after July the 1st. There are definitions of existing business relationship and existing non-business relationship. And if, for example, you were an existing client of Miller-Thomson, that would be inside the existing business relationship. If you were a member of a golf club or other not-for-profit, you would be inside an existing non-business relationship. The problem with this implied consent is that it's time limited. It expires 2 years after the end of the business deal or 2 years after the end of the membership. And then you have to have a system to purge those contacts from your database. During the transitional rules, we get 1 free extra year until July the 1st, 2017 for these implied consents. After that, those will expire and you'll have to do housekeeping for people who have not been dealing with you. The other common one is going to be a conspicuously published email address. Say, for example, for one of my clients who manufactures fuel, we talked about they would still be able to market by sending notices to the web contact of, say, the fuel manager of a fleet vehicle customer. That fuel manager has as his or her duties the job of knowing what fuel supplies or fuel deals or promotions are out in the marketplace. It would not be acceptable if I ran a vacation or travel business to send that same fuel manager information about vacation plans, because that is not their job duty. Then there's also, well, basically the one in the middle about conspicuously published or has disclosed their email address to you, such as giving a business card at a conference, and the information is about relevant to the person's job or duty. As noted, This expires in 2 years. We get a kick at the can for a 3rd year. Existing business relationship also applies for 6 months where the sender has received from someone an inquiry about their product or service, or possibly say an application for a job posting. But that, as you note, is if you don't make that into a positive relationship by the purchase, sale of goods or service, or start an employment relationship, that one is much more time limited. Non-business relationship, this applies for charities, political parties, and candidates. Yes, you will still get donation requests or contribution requests from charities and political parties and candidates. And it has a time limit of the 2 years. And then the one about members for 2 years. This is the slide about the transition period, giving us the extra 1 year on top. When you are sending out a CEM, you've got consent or you've got implied consent, you must at the bottom of your email or your message identify yourself, or say your marketing company that's sending the message out for you with the prescribed information, and that has to be an active address to contact you for 60 days. That won't apply to most of you. You're not the fly-by-night people who set up a website today, defraud someone, and disappear tomorrow. And you must give them a chance to opt out or unsubscribe from receiving messages. The unsubscribe mechanism. You'll probably want to think about your systems in giving some granularity of choices. You probably don't want them to unsubscribe from all, and for marketing you may want to make sure they have the chance to subscribe to different choices. Say, for example, at this law firm, we have set it up that for our marketing materials, we list the different newsletters, we list our seminars, we list various events that we hold, and we allow people to choose what information they would like to receive. Our original system only allowed black and white. Subscribe to all, unsubscribe from all. In anticipation of CASL, we added an extra software feature that gave our users of our information choice. And so when they get an unsubscribe mechanism, it will take them to the page that allows them to select one, more, none. There is a choice of unsubscribe from all. And when we receive a request to unsubscribe from one or more or all, we must give effect to that in our system for 10 days within receipt of that request. It must be free to the recipient to do this. And everything about your unsubscribe link must be clear and prominent and easy to do. At one speech, the regulator said she did not want people to click on a link, to click to a web page, to navigate a web page, to click to another portion of the web page, and finally find where to unsubscribe. So it must be prominent and it must be easy to do. Well, the exemptions. Some commercial electronic messages are actually excluded from CASL. First off, if it isn't commercial, then it's not caught. That's a hard one to do, because even where we're only sending out the newsletter saying the Supreme Court of Canada decided X and saying nothing else, you would probably guess that law firms don't spend the time to read this and create newsletters just for fun. One of its purposes is to encourage people to contact us if they have a problem about that decision. But some are excluded from the consent requirements, but still subject to having to have the mandatory information included. There are definitions in the regulations about personal relationships and family relationships. Those definitions are more narrow than you might think. But if you fit inside the definition, you will be exempt from CASL. Note, If you do friends and family marketing, you have to be very careful about these definitions. In one speech, the regulator said that people should be giving the definitions of family relationship and personal relationship in their advertising materials to warn people not to forward their friends and family campaigns beyond the limits of these definitions. I've seen one draft of a friends and family campaign that now says, click, I certify that the person I am recommending is part of my family or with whom I have a personal relationship. Because when we get to the penalties, you will see that entities are vicariously liable for the acts of their employees or their agents, like your marketing company, for breaching CASL. So running a non-compliant friends and family campaign may get you into really serious trouble. Do you also have an exemption if it's an inquiry, solely about an inquiry related to a commercial activity? Say, for example, the application is coming into a business seeking an employment position, or it's solely about the inquiry for the fuel prices. So that's receiving a message from someone else. The next one is responding to that message. This is one free kick at the can at that one. Yes, the statute is so broad they even had to put an exemption for messages sent internally within your own business, as long as the message concerns the activities of the business. So now we have to teach our people that, yes, it's okay to send me an email between me and another lawyer about a file, but unless I really know that person for a personal exemption, it would be not good for me to send out an email saying the Girl Guide pack is having a spaghetti dinner on Saturday and I'd like you all to come and spend money at it. There's also an exemption, and this is an important one. This is like the fuel supply. Messages sent between businesses that have a relationship that's not defined, it's not the existing business relationship, and the message concerns the activities of the organization. You cannot unsubscribe to stop me sending you an email to demand payment for one of my clients. Or if it's about a safety matter, such as you have a product recall that because something is wrong with the children's crib and there's a product recall for a safety matter. The banks got the next one. So for messages sent by your bank to you about your online banking portal, that one's okay. Received on an electronic messaging service that already has the mandatory contact. If you use a BlackBerry, BBM would be one of these. And if you're sending an email outside Canada or to someone who you believe is outside Canada, but then you must obey the laws about electronic messages of the recipient's jurisdiction. More exemptions. A registered Canadian charity may send a message primarily for the purposes of raising funds. Note, the purpose of raising funds is not the definition in the Income Tax Act of fundraising. And so there's some issues about whether if you send out a newsletter that says we have done very good works with your charitable donations and now you want to send us some more money so we can do more good works. If it's primarily for raising funds, is that newsletter now part of your cost of fundraising for your disclosures of your cost of fundraising under the Income Tax Act? That's being considered. The regulators under CASL hadn't thought about that. We mentioned the political parties and candidates. Exempt from the Act are two-way voice communications. You can always pick up the phone and call someone or Skype them. However, subject to the do not call list. And you can send faxes and voicemail messages to someone's account. So you know when you pick up the phone and it's a pre-recorded voice, subject to the do not call list, that is also outside CASL. So here's another list of things that are also exempt. By now you'll probably have your head spinning and saying, oh my goodness, how am I going to figure out how I've got express consent or what I'm going to do about implied consent and all these exemptions? My goodness, it is difficult. At the firm, we could not figure out how we would train 1,100 people in 11 cities in 5 different provinces in 2 languages how to deal with all of these choices. We have therefore chosen to, for example, put the mandatory content and unsubscribe mechanism in every email that we send out. It will automatically be there without the sender having to think or having to parse through the act and then deciding whether or not to add the mandatory information. And we are automatically sending all of our promotional materials out through our system that records unsubscribes so that we can engage and enact and honor people's unsubscribed choices. We have defaulted as if everything we send out is captured by the Act, and we've just simply not had to deal with all of these exemptions. Why do you care? Well, the regulator doesn't have the capacity in Ottawa to come after us and prosecute us individually. We certainly hope. What they have done, though, is to scare the bejesus out of us by the size of the penalties that are available. So on individuals, it's up to $1 million for violation. That's important because we'll talk about director liability in a minute. And for corporations, it's up to $10 million. You've probably seen in the press in the last year that the Competition Bureau has received awards in the $10 million range for people who have, I think there was one in which certain of the candy companies were said to have agreed about price fixing on chocolate, and they paid $10 million each for that. Well, that's the same sort of penalty range. There's the private right of action. And if you think class action boutique and your company has a breach of your systems and a bulk email goes out not as planned, well, that's up to $200 for each electronic message sent, up to $1 million per day that the breach continues. There's other things in addition to criminal sanctions, which is by and large the Competition Bureau for the really nasty fraud and phishing. In addition to the monetary penalties, there is extended liability. So officers and directors are personally liable for the wrongful acts of the corporation, and the corporation is vicariously liable for the acts of its employees or its agents. Think your marketing company. The risk of class actions and the international prosecutions, and the prosecutions will come probably from offenses reported to the Anti-Spam Reporting Center. Well, I hate to scare you further, but that could be as easy as someone flipping their email they received from you over to the Spam Reporting Center. We think they'll be deluged initially and just be overwhelmed, and we understand they've got algorithms built into their programming to try to weed out certain kinds of bad conduct. Oh my goodness, so there's only about 89 days to get ready, and I've just told you an overwhelming amount of information. You may have a due diligence defense, and that's what you need to focus on now. What policies are you going to have about how emails can be sent out, how marketing materials can be sent out? What is acceptable for bring your own device to work? If they're using your server to send out all kinds of emails about spaghetti dinners this coming Saturday to people who haven't given consent to your organization. And you have to be able to demonstrate that you have made policies, you've instituted procedures, and you've done your best to address CASL compliance. And not just once, but you're actually doing ongoing training and ongoing monitoring to ensure your policies are being honored. What to do? Well, you're going to focus on what is the law and what do we have to do to comply with the law, and then setting up your due diligence defense to be able to be ready in case of a complaint. Here's a checklist of some common things that we're finding all of our clients have to do. And you probably did step number 1 about doing an internal audit when you got to privacy compliance. You were looking at what personal information did you collect, what purposes did you use for the personal information, how did you use it, and where did you disclose it. Now you need to figure out what CEMs are we sending, to who, how are we sending them out, and why are we sending them out. And when we started to parse through in the companies that form Miller Thomson, for example, I had no idea what programs our librarians or our accounting people used and where they sent messages, and were they suppliers, were they government officials, how did I know who they were sending things to. We had to sit down and analyze it and figure out how our systems could handle CASL based on what we sent and to whom we sent it. Then we had to figure out what forms we were going to use to develop to capture express consent. You probably have started to receive requests for consent under CASL from regulators. So for example, if you're at a profession, many of the colleges that regulate professions have already started to send out requests for consent. We are sending out requests to consent about our marketing materials, and we are capturing express consent before July the 1st. Why? Because after July the 1st it will be an offense under CASL to send an email to collect consent. So there's a flurry of activity happening now while people try to capture express consent. Or building forms. If you were, for example, a credit union, you would want to have on your credit application or your new account opening form CASL consent. To capture consent, express consent, which is not time limited until I unsubscribe, at the very first touch point between me as the consumer or customer and your business or operation or your charity or your school or wherever you are in capturing information and capturing email addresses. So we are indeed seeking to replace implied consent with express consent prior to July the 1st. How are you going to store it? So if you were collecting the consent from me at the retail counter with a form, where will the forms be maintained? If it's oral consent, where would you look to find the record of getting the oral consent? Ensuring that your systems can honor the unsubscribe request. Developing an unsubscribe mechanism that's easy to do. Drafting compliance policies, and you might, for example, have to update your privacy policy. For example, your privacy policy may have us opt out for getting your marketing materials, but now you need positive opt-in to send those marketing materials electronically. Your web user and your privacy and your CASL policies all need to be in sync with one another to make sure your practices are uniform. What are you developing for monitoring CASL compliance? For example, we have just done seminars internally to train everybody about CASL inside Miller Thomson. Well, now we're dealing with HR and the IT department. How are we going to train new employees? And reviewing your insurance policy. You may get insurance for defense costs, particularly if you're an officer and director. You may have your E&O policy for a director and officer for defense. However, generally speaking, insurance policies do not pay fines and penalties. So those large monetary penalties, you cannot download the risk to your insurance policy. We have spoken to a number of insurers, and what we have seen so far is that there is no appetite on the street to actually want to sell insurance. So your compliance program will be very IT dependent. And our contact management system, for example, needed tweaking. we're working with our accounting department to determine how long it's been since we actually haven't contacted or had a bill paid by someone for the existing business relationship issue. There's just been a whole bunch of work to do. So software capabilities are a real pickle, and I know for many of you there is no budget for that, or worse, no IT department's capacity to take care of that for you. So other compliance considerations, we've already talked about the July 1st, trying to get this positive opt-in consent, the touch points where you're going to try to capture express consent in your forms, updating your policies, database housekeeping. Can you record consents and unsubscribes when they come in? Here's an interesting one. Your third-party service provider, say your marketing firm or your webmaster agreement, they may now need covenants and indemnities in your favor if they breach CASL, causing a complaint to you. Internal user policies such as bring your own device, and you also have to remember that there's other CASL consent that you may need if you alter the transmission data in an electronic message. That's usually from ISP providers and other technology companies. But the one that is going to impact a lot of businesses is installing software on another person's device. For example, your loyalty program app, or if you've got your device and say a large airline allows you to check your reservations and check in online, those sorts of downloads all now need prior positive opt-in consent. Finally, here's the link to the website from the CRTC, so fightspam.gc.ca. You can go there to find the Act, the regulations, the bulletins, the frequently asked questions as they are posted from time to time. We also on our website have a CASL portion where we have posted information, articles. There's an hour-long webinar there with more information about CASL, as if this wasn't long enough and your head wasn't swimming already. So I've now come to the end of the session in my presentation, and it's time for any questions. So if you wish to type in your questions, I believe it's the chat box that's available to you to do so. I will do my best in the next 10 minutes to try to answer some of your questions. At the moment, there are no questions in the chat box. I'll wait a couple of minutes. Dana, is there any information you need to give people about how to enter a question?
No, I'm checking here as we're going through this, and it seems like people can answer, put in questions, or they could add in the chat. But if you have any questions later, feel free to email me. As Jennifer mentioned, I'll post the slides online as well as the entire webinar. And thank you very much for taking the time out of your day to present, Jennifer. And to everyone else, I hope you guys have a great day.